But here, the Chief Minister's wife issues a letter on 110. On the same day, a detailed resolution is passed and an order is passed, which your lordship will find at page 70, Annexure M.
It was when, my lords, MUDA allots 14 sites and the sections.
Sharing of information
Sharing of
in respect of Shri Siddaramaiah and others.
Please come.
Sites. I'm sorry, it is not confined to only 14 sites. Because there was a chief minister of the state which was involved, probably it has drawn attention to the first 50 paragraphs. But the complaint is that MUDA has been systematically granting and allotting sites, violating every rule in the book.
The sites did not go to the accused by way of sale, purchase. It is by way of allotment.
Yes.
In lieu of usage of the lands of the accused.
Fine.
So here it is not that money is laundered.
Which it is done 4 days after the FIR is registered. My lords, 2021 was the allotment. 27th was the FIR registered.
This is to show how we have found dozens of people purchasing property in the name of their relatives.
It is with them.
But I think the other side should show patience. So, sir, please come back with your rejoinder. Please come back with your rejoinder.
I am aware of
I made notes when you made submissions. So when I make submissions, please make notes.
Yes.
Please look at the properties in the name of his relatives. Grandfather,
So
sister.
many.
Yes. Grandfather of wife, sister of grandfather of wife, son of sister of grandmother, wife of son of sister, father-in-law, servant. It is all, my lord, we have discovered.
The MUDA allotments.
Yes.
Second paragraph, illegal allotment of sites. Now this is part of investigation of the predicate offense. Please notice next one, illegal denotification of land. This is being investigated in the predicate offense.
No, that's the preamble they have drawn to what they are saying.
They say this is what they are doing and passing information. Please notice each and every one, my lords.
During the course of investigation, 2 searches were undertaken, directorate. During the course of search,
and then they give a summary for everything.
the following was revealed.
And then what? Illegal denotification of land, which is what is being investigated, whether it's illegal or not. On the next page, my lords, please notice illegal conversion of the land for residential purpose. Then, my lords, after all that, my lords, they would say, we have attached certain properties. Page 41 is the provisional attachments done by them to about 160 sites that had been allotted. In its investigation into generation of proceeds of crime, not permissible at all. Your role comes after there's a definite proceeds of crime and a laundering of that.
You have so many names are there.
How do all people who have been allotted, my lords, allottees, attachment
Unrelated to.
and it is unrelated to this 14 sites. 14 sites are given back. There's no attachment of the 14 sites. Then how is it that I'm receiving summons under 50?
My lord,
2023.
June 2023. ಅವ್ರು ಏನಾದ್ರು ಒಂದು ತೋರಿಸ್ಲಿ ನೋಡೋಣ ಜೂನ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಟು ಜೂನ್ 2023
ಇಲ್ಲ ಸರ್ 21 ಗೆ ಎಲ್ಲ ಆಗೋಯ್ತು
ಅಷ್ಟೇ my lord, that MUDA commissioner who passed the order accepting the surrender and cancelling the allotment that was made earlier, my lord, he is the petitioner before a coordinate bench of dishonorable court.
That same.
Yes, that's Satish.
My initial submission would cover both the petitions. Then, my lord, I will segregate. My lord, at the outset, my lord, I recall para 103 of Y. Balaji judgment, where Lordship Justice Ramasubramaniam very eloquently says that when there is when the predicate offense is of corruption, then proceeds of crime is a Siamese twin. My lord, we are dealing with a case of corruption, and my lord, by applying that logic rendered by the Honorable Supreme Court, the generation of proceeds of crime is a Siamese twin.
No. Corruption in the sense?
It is a case of corruption. My lord, the provisions of the PC Act were not. Yes. Section 13 has been pressed into service. So we are dealing with the predicate offense is one of corruption, and the generation of proceeds of crime as per Supreme Court, my lord, is like a Siamese twin. The moment the predicate offense is committed, along with that is generating with itself the proceeds of crime. My lord, would your lordship first take up the writ petition filed by accused number 2 in the predicate offense? In that, my lord, she has produced
Parvati.
Yes, Parvati. She has produced a copy of the complaint. My lord, the complaint predominantly, my lord, begins at page number 41.
Mm.
As your lordships are aware, it predominantly deals with the allotment of 14 sites
Mm.
as to how the accused number one bent every single rule and accommodated allotment of those 14 sites.
Mm.
But where I would like to draw your lordship's attention is page number 51, para 52. Page 51, para 52.
Mm.
Similar illegal allotments are being done by MUDA officials and other political and influential persons, thereby causing loss to the tune of more than 5,000 crore to the state exchequer due to embezzlement and illegal gratification. The above mentioned accused persons, by illegally allotting thousands of sites, have received huge kickbacks. These illegal acts and corruption has gone into the roots of MUDA since the year 1990.
No, this
Hence,
is the private complaint.
private complaint is. This is in fact, the private complaint is made part of the FIR. The FIR description of the offense says the entire complaint. And then, my lord, please have a look at para 56 on page number 52. Page 52, para 56. Furthermore, the corruption and irregularities committed by the accused number one is just a tip of the iceberg. In fact, many government officials and others at the relevant point in time were actively involved in larger scam, which needs deeper investigation, inquiry, and trial in due course. The complainant reserves the right to bring so and so. So why I am reading this is, I heard my learned friend Mr. Chauta trying to confine the investigation only to 14 sites. I'm sorry, it is not confined to only 14 sites. Because there was a chief minister of the state which was involved, probably it has drawn attention to the first 50 paragraphs. But the complaint is that MUDA has been systematically granting and allotting sites by violating every rule in the book.
This is a private complaint that triggers predicate offense.
Yes.
Now, if this very complaint is triggering ECIR,
Yes.
then it means that you're investigating into the predicate offense, you're
No,
conforming
no.
to the
My lord,
process.
I'm
No,
not.
itara complaints
At the outset,
will,
my lord,
complaints
I
will come.
I would like to make it clear.
Complaints will come
My lord,
and go.
neither do I have the power to investigate in the predicate offense, nor we are interested.
So that is
But
there.
then, my lord, in these kinds of cases, the moment the predicate offense is committed, there is generation of proceeds of crime. Now, proceeds of crime are broadly
So you come
in
back
nature.
to the statement. In these kind of offenses, when the predicate offense is registered, there is proceeds of crime.
Yes.
Is what you say.
Yes.
All right.
Yes.
Now,
No.
you confine it to the accused in the predicate offense, or you go on, inquiring into everybody.
No, my lord, I am not concerned with the accused in the predicate offense.
That's all.
I am
Yes.
concerned with the generation of proceeds of crime.
Yes.
My lord, after the FIR was registered, my lord, we within 4 days we registered the ECIR. I heard my learned friend Mr. Chauta say that what was the great hurry. But I would say our officers have demonstrated great alacrity, sharpness, and efficiency. Why should there be delay? I would say, what is the difficulty in registering the ECIR the very next day? There is no law which prevents me from registering.
There is no bar.
So there
Even
is no
Vijay
problem. The
Madanlal
moment I
does-
come to know that there is an offense, the next day I can do it. So therefore, I would say that we have shown efficiency in initiating the proceedings under the PMLA within 4 days from the date of registration of the predicate offense. No, my lord, what happened after we commenced the investigation is some material that we have unearthed, my lord, I would like to place before your lordship in a sealed envelope. My lord, and I would like to now take your lordship through some of them because that pertains to the other writ petition. Because the my learned friend Mr. Nagesh's client has been claiming that I'm in no way responsible to these 14 sites. But then the investigation has revealed not just these 14 sites, there is quite a lot of muck which is involved. Not some details that we have discovered during the course of investigation. Lordship may kindly have a look at it. Open matter. But we are in the midst of the investigation now.
Office given what?
ಇಲ್ಲ ಆಗದು my lord, these are we are at the time of investigation now. We cannot compromise until the investigation is complete.
How do I answer it without knowing?
No, that's not for the purpose of the court.
ಅಲ್ಲ ಕೋರ್ಟ್ ಸೀಲ್ ಕವರ್ ಕೊಡ್ಕೊಡ್ದು ಅಂತ ಅನ್ಬಿಟ್ಟು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ has time and again said it. Yes, yes.
My lord, would you
Bench headed by Justice Bopanna has ruled that.
Then
Yes, the sealed cover.
why touchy about
information,
sealed cover?
Yes, needs to be deprecated.
That's the judgment.
my lord, one has to see the context and the nature of investigation. My lord, would your lordship kindly take page number 1?
It should become possible for us to meet the challenge.
My lord, page number 1 at the bottom, my lord, last para.
They have referred to it in the statement of objections, fine.
We have. Some elements. Investigation reveals that the proceeds of crime generated in the form of illegally allotted sites are being transferred, that is routed, layered in the name of relatives, associates of real estate businessmen, MUDA officers, influential persons. The details of such instance revealed during the investigations are appended below. Shri so-and-so, he obtained one site in the name of his son of his brother, without paying money from so-and-so businessman. The examination of issue revealed that the
How
contradictory.
does that concern the present
no.
person?
No. What I want to demonstrate is,
He may be at the helm of affairs
No.
there.
the
Being the
the
minister.
part that I am now reading is to show how influential people are acquiring the proceeds of crime in the name of their relatives.
That is a generic term. I'm asking what is specific again.
On that, that is on the left side. That is on the left side. That is para A and B. You know that I have
No, because 50-50 scheme.
I have stated in my
was there earlier,
I have stated
earlier to him, and in fact, the
No, no.
50-50 scheme is
In
scrapped
fact,
now.
I have stated in my statement of objection that during the course of investigation, one of the persons investigated has stated that he was subjected to pressure from the office of the petitioner in the other case to do certain allotment.
Where, how the?
In the statement of objections, I have stated it. This is to show how we have found dozens of people purchasing property in the name of their relatives, which are all proceeds of crime. For example, please have a look at
Proceeds
the.
of crime, whose proceeds?
No, these are all proceeds of, these are properties.
Proceeds of, whose proceeds of crime? Which accused is proceeds of crime?
No, this is not relating to the 14. These that I have referred to in page
So
3.
it is, this investigation that you have conducted now has nothing to do with the 14 sites.
No, my lord,
No, that's, you should be
our investigation is in relation to the ECIR that you have registered, which is pursuant to the FIR in crime number
Correct.
11.
correct.
During our investigation, we are not segregating these 14 sites or anything else. We are conducting investigation. There are,
But whatever you have said here has nothing to do with the 14 sites.
on the right hand side, It-
Right, left, yellow, 14 sites ಬಗ್ಗೆ ಇಲ್ಲ.
it may be, some of them may be generating out of that. My lord, please have a look at the name.
AJ sir. Now, proceeds of crime
Yes,
of this Parvati
yes.
has resulted in purchase of all this? Is that
No,
that's
no,
not
no.
your
It need
submission
not
at
be.
all?
It need not be.
That-
Lord,
that is not it.
that is, Lord, which is why we are calling her.
Ah.
We want to investigate.
No, these 14 sites
Yes.
now, whatever had been purchased or had been allotted, it's not purchased actually.
Yes.
It is allotted by MUDA.
Yes,
If ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟು ತಗೊಂಡಿದ್ರೆ, then that's a
yes,
different thing.
yes.
It is allotted by MUDA. Allotment is pursuant to that allotment. These factors that now you have
No,
gathered,
these, Lord,
is
these
it
are,
proceeds of crime of Parvati?
no.
Gone back
Adhe,
to
that's
them.
what, then there's.
It is with them.
Lord,
What I was-
I think the other side should show patience. Allah. So, sir, please come back with your rejoinder. Please come back with your rejoinder.
I'm aware of.
I made notes when you made submissions. So when I make submissions, please make notes.
Yes, yes.
Lord, what we discovered during the course of investigation is,
No, no, I
That
just
apart-
clarifying myself.
Lord, as the complainant has pointed out in the PCR, the allotment of 14 sites is only a tip of the iceberg.
Ah.
What the MUDA officials would do is, I'll give one modus operandi. Somebody sat down and pulled out a list of acquisition of land in and around Mysore since 1966. The CITB allotment. They would pull out the details and then make create a narrative that somebody's land acquired in 1966, he has not been compensated, and then they would give him a prime MUDA site in Vijayanagar or one of those prime areas.
So there's.
Now, in relation to that, there is money transfer, there is purchase of sites. So that is exactly what I have pointed out.
Those are specific names you have.
Yes,
All right.
yes.
That is the information you're going to share with others with regard to those persons. Now, where is the proceeds of
Lord,
crime
I'll come
here?
Lord, I'll come to that. Lord, there is a specific purpose why I'm reading this. The part that I'm reading at page number 345 is only to satisfy your lordship as to why in my general questionnaire, I asked people about the details of their relatives.
So, ಎಲ್ಲೆಲ್ಲಿ ಹೋಗಿದೆ?
My lord, please look at page 4. Please look at page 4. Somebody was a former commissioner of MUDA. Please look at the properties in the name of his relatives. Grandfather,
So
sister.
many.
Yes, grandfather of wife, sister of grandfather of wife, son of sister of grandmother, wife of son of sister, father-in-law,
ಯಾಕೆ ಅವ್ರೆ
servant.
ಅವ್ರು ತಗೊಂಡ್ರಕ್ಕಾಗಲ್ವಾ?
It is all, my lord, we have discovered.
ಇದು ಮೂಡ ಅಲಾಟ್ಮೆಂಟ್ ಸರ್.
Yes. No, this part of my submission is to satisfy your lordship that I should be permitted to ask this information about their relatives. Now, my lord, my learned friend, Mr. Nagesh's client had a grievance that why are they asking details about my relatives? Now, we want to know that he, as the minister for the urban development department, was involved in a whole lot of allotment of sites. We have questioned his private secretary. A couple of people whom we have examined in MUDA have dropped names. So we want to know whether there is any transfer of proceeds of crime to his relatives, because the former MUDA commissioner, please look at the
Whose relatives?
yes, of the petitioner in the other petition.
Other petition.
Yes. So we want to know whether there is any similar. Please have a look at the previous MUDA commissioner. He has purchased a whole lot of sites.
Proceed
Yes.
against him.
Yes. No, we will. So therefore, to gather information, we are well within our rights to ask, please furnish the property details of you and your relatives. Because there is a history.
Questionnaire.
Yes, questionnaire. Now questionnaire, the other question about the questionnaire is that we have attached it to the format of the summons. Now, let us say I had not attached this to the summons. So I would have asked the same question when the noticee came to the for the inquiry. Can the petitioner then say that he could not have asked me so and so question during the course of investigation? It is only an advance information that if you have any of these properties, please bring the record. So therefore, but these cannot be subjected to judicial review. I am within my right to ask these questions.
So
Because
you
there
only
is a
say-
history.
You only say that your investigation and inquiry
Yes.
or questioning him will be on these parameters.
Yes, yes, on this. First, my lord, I want to understand what are the properties. If it is lawful, my lord, I have nothing to do. If they have any properties to which they do not have any explanation, or if I am able to some link to the proceeds of crime, then I can proceed. That is what exactly para 431, which, my lord, I will read next in Vijay Madanlal Chaudhary. So therefore, my lord, this investigation has revealed that there is a whole lot of allotment of sites illegally purchase and allotment of sites. And please have a look at certain the bank transactions, if your lordships will see. Anyway, Lord,
You're sharing this information with other authorities about Dinesh Kumar.
yes, my lord, I have to the authorities we have already shared, Lord, under 66(2). Lord, as far as there are certain dates which are relevant. Lord, pursuant to your lordship's order on 4/9/2024, the FIR was registered on 27/9/2024.
24/9/20.
I'm sorry, 24/9. 24/9/2024. 27/9, the FIR was registered. 1/1, the ECIR was registered. After this, now someone's issue ಮಾಡಿದ್ದೇವೆ first. On 9/1, date ಏನಿದೆ?
Yes, sir. Third, sir. Third.
ಯಾಕೆ ಹಾಕಿಲ್ಲ ಇಲ್ಲಿ? ನಾನು ಹಾಕಿದ್ದೆ, ನಮ್ದು ನೋಟ್ಸ್ ಎಲ್ಲ ಹಾಕಿದ್ದೆ.
Third, which is
My lord, after the ECIR was registered,
3/10/2024. ಹೌದಾ ಸರ್?
ಇದರಲ್ಲಿ ಇಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ, same sir. 3/10 deed of cancellation.
Okay.
Next.
Lord, 1/1/2024 we registered the ECIR, and ಅಲ್ಲಪ್ಪ ಇಲ್ಲಿ 1/10 ಅಂತಿದೆ, expressing intention to surrender. Okay.
Yes, sir.
And then your lordship will notice that on 1/10/2024, the petitioner, that is Parvati, issues a letter expressing her intention to surrender the sites, a copy of which, my lord, has been produced by her. Please have a look at that letter.
Page?
Lord, that your lordship will find at page number
69.
61, no, sorry,
69.
69, annexure L. Lord, the second part. ಮುಂದುವರೆದು ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ನನ್ನ ಪರವಾಗಿ ಕಾರ್ಯಗೊಳಿಸಿದ 14 ನಿವೇಶನಗಳ ಕ್ರಯಪತ್ರಗಳನ್ನು ರದ್ದುಗೊಳಿಸುವ ಮೂಲಕ ನಾನು ಪರಿಹಾರ ನಿವೇಶಗಳನ್ನು ಒಪ್ಪಿಸಲು ಮತ್ತು ಹಿಂತಿರುಗಿಸಲು ಬಯಸುತ್ತೀನಿ. ನಿವೇಶನಗಳು ಸ್ವಾಧೀನವನ್ನು ಸಹ ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಮರಳಿ ಹಸ್ತಾಂತರಿಸುತ್ತಿದ್ದೇನೆ. ದಯವಿಟ್ಟು ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಆದಷ್ಟು ಬೇಗ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳಿ. So she issues this letter on 1/10. Lord, I heard my learned friend say, what was the great hurry? Lord,
that's why hurry
it is time for me to borrow that expression. But in this case, my Lord, we have seen, my Lord, common experience has shown.
Tearing
that-
hurry versus tearing.
Yes, common experience has shown that how when a common man goes, makes a request, it takes weeks, months, years for the government to act. But here, the chief minister's wife issues a letter on 110. On the same day, a detailed resolution is passed and an order is passed, which your lordship will find at page 70, annexure M. ಎಲ್ಲ ಮೊಬೈಲ್ಗಳನ್ನು ಸಂದಾಯ ಮಾಡಲು ಅವಕಾಶ ಕಲ್ಪಿಸುವುದರಿಂದ ಸದರಿ ನಿಯಮಗಳಂತೆ ಹಾಗೂ ಏನದು ಏಕಸದಸ್ಯ ಸಮಿತಿಯ ವರದಿ, ಲೋಕಾಯುಕ್ತ ತನಿಖೆ ಹಾಗೂ ಇನ್ನಿತರ ಯಾವುದೇ ತನಿಖಾ ಸಂಸ್ಥೆಯ ವರದಿ, ಆದೇಶಗಳ ಷರತ್ತುಗೊಳಪಟ್ಟು ಭೂಮಾಲೀಕರ ಸ್ವಇಚ್ಛೆಯಿಂದ ಬಿಟ್ಟುಕೊಟ್ಟ 14 ನಿವೇಶನಗಳನ್ನು ಮಂಜೂರಾತು ರದ್ದುಪಡಿಸಿ ಆದೇಶಿಸಿದೆ.
Subject to everything.
So therefore, my lord, the acceptance by MUDA is subject to other authorities, including the ED. Because our investigation is connected to those 14 sites. Those 14 sites, my lord, clearly satisfy the definition of section 2(1)(u) proceeds of crime, because they are property derived or obtained by a criminal activity. So the criminal activity is under investigation before the court, my lord. So the prima facie it is proceeds of crime and it is subject to that. Nevertheless, then, my lord, after this order was passed, then a deed of cancellation was made, Lord, which your lordship will find at the next page.
Same day.
It is, yes, it is same day. These are all happening at the speed of light. But it is set to be executed on 110, but the registration takes place 2 days later on 310. The registration. So therefore, the registration date is available there.
That's all.
Now, my lord, my respectful submission would be, my learned friend, Mr. Chauta, propounded the theory of enjoyment of a property. My lord, if my respectful submission would be, if the proposition that a person can be proceeded against, even under section 50, for the purpose of investigation, that only if that person is continuing to enjoy the property, then, my lord, it will amount to turning the entire PMLA jurisprudence and the law on its head. Because at any point of time, the person, someone can say, hey, please take over my proceeds of crime. Like, I want to wash off my hands, and then say, proceeds of crime is not with me. So that possibility is there. Nevertheless, in this case, when did the proceeds of crime get generated? It is the day it was allotted.
2020.
The allotment took place because of a criminal activity. The proceeds of crime were generated. My ECIR registration is only an administrative document. When I register an ECIR, my ECIR is not a FIR. It is only a document for administrative convenience.
One factor is, the sites did not go to the accused by way of sale, purchase. It is by way of allotment.
Yes.
In lieu of usage of the lands of the accused.
Fine.
So here it is not that money is laundered for that proceeds of crime have emerged because of that. It is an allotment. Allotment is legal, illegal.
Laundering.
It's an allotment.
Laundering has a huge import. It's got a very, very wide import.
No, what I'm trying to tell is, ನಾವು ಇಲ್ಲಿ ದುಡ್ಡು ಕೊಟ್ಟು ತಗೊಂಡಿದ್ರೆ ಪ್ರಾಸಿಟ್ಸ್ ಕ್ರೈಮ್
ದುಡ್ಡು ಕೊಟ್ಟು ಈ ಪ್ರಶ್ನೆ ಬರ್ತಿರ್ಲಿಲ್ಲ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ನೋ ದೆನ್ ಯು ಕುಡ್ ಬೇರೆ ವೆದರ್ ದಟ್ ಮನಿ ಇಸ್ ಟೇಂಟೆಡ್ ಮನಿ, ಆ ಮನಿ ಈ ಮನಿ ಇಸ್ ಅ ಡಿಫರೆಂಟ್. ನಾವು MUDA ಅಲಾಟ್ಸ್ ಇಟ್. MUDA ಅಲಾಟ್ ಮಾಡಿದ್ಮೇಲೆ ಇಫ್ ದಟ್ ಇಸ್ ನೌ ಲಾಂಡರ್ಡ್.
Lord, what we have to see is, if we have to go by the definition of 2(1)(u) of proceeds of crime, Lord, there is no dispute that 14 sites are property.
That is no dispute.
It's a property. Now, how did the property get generated? It is because of a criminal activity.
Allotment.
It is what precedes the allotment is a criminal activity.
Acquisition of the land of the
No, yes, that is where the criminal activity has taken place.
That is where.
Not how her.
That is where.
Not if we go back,
land that had already been.
Yes,
it is allotted.
Lord, I would say,
it is allotment.
I would say, Lord, in these proceedings, Lord, we should keep away from that. What took place, whether the criminal activity is for some other court to decide. As far as these proceedings are concerned,
We're not going
these
back.
proceedings are
Predicate offense, we're not going back.
Yes.
only-
So there is a predicate offense. In the predicate offense, it will be decided whether there is a criminal activity or not, whether it is proved or not. But the FIR says there was a criminal activity. And because of that criminal activity, these 14 sites are generated, which is proceeds of crime. Now, these proceeds of crime, my lord, which the husband of the petitioner, in his affidavit filed, the election affidavit, he has shown it as property of his family. So I would say that is one attempt to claim that it is untainted property. The affidavit filed by the husband of the petitioner, showing that my family today owns 14 sites, was the first attempt to show that it is untainted. The second attempt is by the petitioner herself, by trying to return it back. By returning back, she is trying to project it as untainted. So therefore, I would say, my lord, that is a fresh count of an offense under section 3. And the contention of the other side, that by the time the FIR, the ECIR was registered, the property has been surrendered, is not true. She already knew that she had issued a letter surrendering the property on 110. She knew that there was a resolution passed. She knew that there was a deed of registration which was made.
Deed of?
The deed of cancellation.
Huh.
But she does not mention it.
Oh, ನಿಮಗೆ ರಿಪ್ಲೈ ಕೊಡ್ಬೇಕು ಸಮನ್ಸ್
ರಿಪ್ಲೈ ಕೊಡ್ಬೇಕಾದ್ರೆ nothing. ಅಲ್ಲ, no, please look at the content.
ಅಲ್ಲ ನೀವು
I am in receipt.
ಶೋಕಾಸ್ ನೋಟಿಸ್ ಚಾರ್ಜ್ ಶೀಟ್ ಇದ್ರೆ
But
ಅದಕ್ಕೆ
ಪರವಾಗಿಲ್ಲ.
ಕೊಡ್ಬೇಕಾದ್ರೆ ಎಲ್ಲ
No, please look at the content. Please look at the content. I am in receipt of your notice dated 3/1, seeking my attendance on 9/1/2025, along with certain information as stipulated in the said notice. I am in the process of collecting necessary details. If she can say, I'm in the process of collecting the necessary details, the details which were already available with her, she could have disclosed. She does not disclose that. So therefore, my lord, a doubt arises as to whether, if we look back now, whether this was all, my lord, that is subject matter of investigation, I'm saying. This requires to be investigated. Whether there has been a backdating of certain documents, there has already been enough muck, but whether this piles on to that is something which we have to examine.
No, what notice did you issue?
Just to come and appear.
ಅಲ್ವಾ?
Yes.
ಅದಕ್ಕೆ ಆ ನೋಟಿಸ್ ತಕ್ಕ ರಿಪ್ಲೈ. ನೀವು ನೋಟಿಸ್ ಅಲ್ಲೇ ಕ್ವಶನ್ ಏರ್ ಕೇಳಿದ್ರೆ ಕ್ವಶನ್ ಏರ್
ಅಲ್ಲ ಆಗಿದ್ರೆ ಮಿಲಾಡ್, if ಕ್ವಶನರ್ ಅಲ್ಲಿ ಇದೆ, ಇನ್ಫ್ಯಾಕ್ಟ್ ನಮ್ಮ ಕ್ವಶನರ್ ಅಲ್ಲಿ ನಿಮ್ದು ಏನೇನ್ ಪ್ರಾಪರ್ಟಿ ಇದೆ ಕೊಡಿ ಅಂತ ಹೇಳ್ಬೋದು. ಹೇಳ್ಬೋದಾಗಿತ್ತು ಸ್ವಾಮಿ, ಈ ನೀವು ನನಗೆ ಕರೀತಾ ಇರೋದು 14 ಪ್ರಾಪರ್ಟಿ ನನಗೆ ಗೊತ್ತು, ನಾನು ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದೆ ಅಂತ ಹೇಳ್ಬೋದಾಗಿತ್ತು.
ಅಂತ ಯಾಕೆ ಹೇಳ್ಬೇಕು?
Anyway, Milord, at this point in time, Milord, I will not answer those questions. The purpose of reading all this is to demonstrate before your lordship that everything is not what meets the eye.
It's your investigation.
If your lordship sees this in the perspective of how
your investigation is right, that it has met more than what
yes,
the eye.
Particularly considering that a letter issued by a citizen is received by a statutory authority, that is MUDA, a detailed resolution and order is passed, a deed of cancellation is executed. Now, all this happening in a span of about 10 to 12, I mean, business hours is about 8 to 10 hours. All this happening is something which needs to be answered. So therefore, my lord, my respectful submission would be that this petitioner cannot say that as on the date of registration of the ECIR, I was not in enjoyment of the property.
As on the date of registration,
The contention was
110/20.
The contention was
110/24.
yes, on the date of registration of the ECIR. So which is and then the other issue is, once it is a proceeds of crime, if you hand over to A hands over to B, the custody will be with B, but it will not cease to be a proceeds of crime. It may be currently the MUDA is in custody of those 14 sites, but I would say that MUDA is in custody of the proceeds of crime. It will not lose its character as proceeds of crime merely because the petitioner has made a surreptitious attempt to hand it over back to the MUDA.
No,
I was about to give that.
A's property is stolen by B. B gives it off to C.
Yes.
Then proceeds of crime is laundered. If A's property is stolen by B and B returns it to A, crime may not go. Proceeds of crime will not.
No, my lord, here, my lord, this is not, even if we go by the IPC logic, if you return the stolen goods, you
No,
cannot
a
claim
thief-
that you
a
are not
thief
committed the
returning
offense.
the stolen goods will not
Once-
absolve him of the crime.
No,
I'm not on that.
Once, my lord, once it attains the characteristic of a proceeds of crime, by returning you cannot cleanse it. My lord, that is laundering. Your attempt to launder it to show that it is white property or clean property
No,
itself is the offense of money laundering.
Where is it laundered? Where is it laundered?
No, you
Acquisition,
claimed.
allotment, where is it laundered, I'm asking?
No, she owned the property. The day.
Owning the property is laundering?
No, sale deed was executed in her favor.
Correct.
Yes.
So where
So
is
she
it-
became the property owner.
How?
She became the property owner
How?
by execution of a sale deed by MUDA
For what purpose?
as a compensation as a compensation, but for a property which was never acquired. My lord, which is why, my lord, we once again go back to the predicate offense, which I do not want, my lord, take your lordship to
Not
that.
necessary. Yes.
That is for another court to decide.
It's all right. Yes.
As on today, there is an allegation that there was a criminal activity. And due to that criminal activity, these 14 sites have arisen.
All right. Yes.
So therefore, as on today, those 14 sites have the characteristics of a proceeds of crime. Merely returning it back to MUDA does not wipe off that characteristic, is my submission. My lord, among the 4 formulations that I want to place before your lordship, the first one is that a challenge to ECIR under 482 is not sustainable. My lord, I have prepared a compilation. We have not made any accusations at all. I'm not sure why my learned friend had to make elaborate submissions on his client is not guilty of certain offense. She is not. This is not proceeds of crime. We have only there is a proceeding which under section 50. My lord, all that I have to establish is that there is an investigation going on in respect of an ECIR, which is in respect of a FIR. Now we have to reassemble that. Is there a FIR? Yes, there is an FIR. Is there a predicate offense? Yes, there are a couple of them. There is 420, there is 471, there is section 13 of the PC Act. Pursuant to that, is there a ECIR which is registered? Yes, we have registered ECIR. Is your investigation in relation to this? Yes, it is in relation to that. Have you summoned both of these petitioners in relation to this? Yes, I have. This is all that I have to establish when I have summoned a person. My learned friend's client need not feel that they are accused and that they have committed an offense punishable under section 3. We want to know from them. We have to gather information from them. We may record, and if we do not find anything, we may not proceed at all. And Honorable Supreme Court says, if you find something, then you can proceed further. So therefore, what we have conducted, in the words of the Honorable Supreme Court, is like a civil inquiry. So in respect of a civil inquiry, initiation of section 482 does not arise at all. Because my ECIR is not a document which is recognized under the code. It is only for administrative convenience I have given it a number. Lord, one more judgment directly on the point is, Lord, please have a look at the Madras High Court judgment at page 19. It is to be borne in mind that ECIR is not registered under the Code of Criminal Procedure, and it is not akin to an FIR which is registered under section 154 and sent to jurisdictional magistrate. The scope of an ECIR has been discussed with the division bench of this court in so and so, so and so. Then brought para 10. Thus, registration of an ECIR is an administrative act that is done by the officers of the Enforcement Directorate for initiation of an investigation under PML Act, which is a special statute, and therefore the same cannot be quashed in excess of the powers under section 482 because registration of ECIR is not under the code. Paragilla. The principle, I am borrowing the principle. Allah, my lord, when I am borrowing a principle of a superior court, the law applied
Lighter ways.
we as counsel sometimes we tend to take seriously. Here, but the difference here is their lordship.
Here, 2006, page 9.
Allah, adralli, in a show cause notice, my lord, at least I make an allegation. When I issue a show cause notice, you have violated this law. You have done this. You are liable to be punished, prosecuted. And then I say, please give reasons. For that, the Honorable Supreme Court says there is no cause of action. Please look at this summons. I said, please come to my office and I want to record your statement. When I have not even made any allegation. So, therefore, my lord, there is no cause of action. In the page 165, Commissioner of Customs, first 2 lines, my lord, their lordships refuse. Interesting judgment is of Raghav Bail. Only 1 line in Raghav Bail, page 167. My lord, the Honorable Delhi High Court said,
Samankar is followed.
yes, and there, page 172, one line. page 172, para 14. There is no violation of any fundamental right or any legal right of a petitioner warranting interference at the stage of summons. So stage of summons, there is no violation.
Under your, that is the companion petition. The senior counsel C. V. Nageshwar Pere. Our summons mantra.
Elrigu apply agutte.
Elrigu summons.
Elrigu. Both, my lord, even for Parvati, my lord, although she is accused number 2 in the predicate offense, as of now, we have not lodged a prosecution complaint at all. We have only issued a summons. And when we issue a summons, my lord, we need not disclose for what purpose we are in requesting the noticee to come. Only after investigation, we'll decide. If there is some material, we'll proceed. If there is no material, we proceed further with others. I thought that was his.
What they're trying to write is about the investigation to the predicate offense. That they can't do.
No, that is.
No, I am giving
66
information.
to
That
a
is posted.
You
No,
are informing other authorities that these are the
let me read Athkodi.
findings of
Annexure R1.
investigation.
No, let me read Annexure R1. I don't find anything contrary to law.
So that's all right.
And anyway, my lord, 66 to it is for that local enforcement authority either to accept it or not.
That's
No.
good. It is not that.
No, let me explain. My learned friend. No, let me explain. My lord, I have referred to. My lord, my learned friend had a problem with illegal allotment, illegal denotification. All these have led to generation of proceeds of crime. Somebody would denotify and get it allotted to somebody, gets money. We have materials for that.
For others,
Why should I not bring it to the notice?
others you bring it to the notice.
Yes.
You are bringing
No,
it
what
to
is
the
what is the
notice.
difficulty of these two petitioners if I bring it?
No,
to the
no,
notice?
predicate offense. These whoever is here, our the proceeds of crime Allah though.
No, for each one of them, there is a different proceeds of crime. As far as Mr. Chauta's clients are concerned, the proceeds of crime quite clearly is 14.
14 allotments.
Yes. As far as Mr. Suresh is concerned, my lord, we have, during the course of the investigation, we have discovered that several approvals and directions were given from his office to the office of the MUDA. So we haven't,
After he assumed office.
my lord, yes, after he assumed office, and it continues. He continues in office. So we want to get some information from you. There shouldn't be no difficulty. It is only for the purpose of gathering information. It is to find out whether there is any, my lord, as someone.
Then what do you say about the coordinate bench? That also was for that purpose only.
My lord, the coordinate bench, my lord, my respectful submission is, my lord, that the certain observations in that judgment are per incuriam, my lord, it is under challenge. My lord, his
Per
lordship,
incuriam to what?
per incuriam to the law declared by the Honorable Supreme Court. It's a per incuriam, I mean, to opposed to para 290, para 431.
Vijay Madanlal.
Vijay Madanlal. Vijay Madanlal, sir. My lord, that para 54, 55, 6 of that judgment requires me to record a prima facie case, even to summon, which is not the law.
Which coordinate bench is?
Yes. It says you should have a prima facie case to even to summon. And I furnished judgments to point out, my lord, there, my lord, the main ground on which his lordship was inclined to accept is that upon going through the reasons to believe, which we gave in a sealed envelope, his lordship felt that it is not sufficient in that case. In that case, against that petitioner, as against that petitioner, his lordship felt it is not sufficient. That is not an argument which is raised in this case. That is not an argument. So therefore, that is the main issue. The main issue was whether the reasons recorded in the reasons to believe is sufficient. And the answer to that, it is not sufficient. It says it does not meet. So therefore, my lord, that judgment would not be of much help. Therefore, my lord, to summarize my submissions, my lord, there is a predicate offense, and pursuant to that, proceeds of crime have been generated, and we have registered a ECIR. In connection to the ECIR, we have merely summoned both the petitioners, and our inquiry is of civil in nature. We want them to produce certain documents. We want them to disclose their property and account details, as also their relatives, because our past experience has shown that proceeds of crime is generally purchased in the names of relatives. So therefore, we want to investigate that. And this investigation is permissible in law. I have followed all the safeguards which are predicated under 17 as well as 50. And the challenge.
Now, if it does not cooperate, what do you do?
Well, they will.
Civil inquiry.
There is a law, we will follow it. I do not want to make a submission.
Arvind Kamath sir.
We are ready. Matter also, but
Fine, yes, all right.
Thank you, sir. Thank you.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದಾರ?
Objections ನೆನ್ನೆ ಹಾಕಿದ್ದಾರೆ my lords.
ಫೈಲ್ ಮಾಡಿದ್ವಿ.
ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿ.
ಅಲ್ಲಪ್ಪ ಇಲ್ಲಿ ಕೋರ್ಟ್
ಇನ್ನೊಂದು ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿ ಇಲ್ಲೂ ಕೊಟ್ಟಿದ್ದೀನಿ. ಎಸ್ಟರ್ಡೇ ವಿ ಹ್ಯಾವ್
ಅಲ್ಲಲ್ಲ ಕೋರ್ಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿ.
ರಿಜಿಸ್ಟರ್ ಇಲ್ಲ
ಇಲ್ಲೇ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಯಾವಾಗ?
ಇದು ಬೆಳಿಗ್ಗೆ ಕೊಟ್ಟು.
ಅಲ್ಲ ಇಲ್ಲಿ ನನಗೆ ಕೊಟ್ಟಿದ್ದೆ.
ಬೆಳಿಗ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes, yes,
ಹಾಗಾದ್ರೆ
has been handed over.
ಕೊಡಿ. ಇಷ್ಟೊಂದು ಆಯ್ತು.
ನಂದ್ರಲ್ಲಿ ಒಂದು 144 ಪೇಜಸ್ ಇದೆ. ಐ ಥಿಂಕ್ ಸೀನಿಯರ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಇರ್ಬೇಕು ಅದಕ್ಕಿಂತ.
ಇರ್ಲಿ
Lectures ಎಲ್ಲ ಸೇರಿ ಹೇಳು.
ಇನ್ನೊಂದಿಲ್ಲ, ಒಂದಾಯ್ತು, ಇನ್ನೊಂದು ಮೈ ಜಡ್ಮೆಂಟ್.
Yes, well, so that date may be of some relevance because one of the aspects which we intend pointing out is the tearing hurry in which the ECIR is registered, which I will point out. Now, my lords, in that list of dates, 6 may be noticed, serial number 6, the date of registration of the FIR,
ಪ್ರಿಡಿಕೇಟ್ ಒಫೆನ್ಸ್.
predicate offense, 27/9/2024. My lords, on the previous day was the 156(3)
That time.
order. So next day, the FIR comes to be registered. My lords, 7/110/2024, deed of cancellation where the 14 sites have been surrendered to MUDA. From this date on, the petitioner is neither in possession nor enjoying the so-called proceeds of crime. The very same day, my lords, when the property is returned to MUDA, the ECIR is registered. Same day, 1/10/2024, which is on 4 days after the FIR in the predicate offense gets registered. Now, my lords, the last part where I mentioned there, the subject matter of that investigation and the subject matter of this inquiry appears to be one and the same. The illegal allotment of 14 sites to the petitioner. Now, with this, my lords, amongst the points that I have raised, which my lords would get in the index, my lords wanted to know on point number 7, as regard the enjoyment of a proceeds of crime, would it be a prerequisite for you to proceed under the PMLA Act? My lords may have page 20, where I have elaborated the aspects of enjoying the proceeds of a crime. My lords may notice there, one of the essential requirements to proceed under the provisions of PMLA Act is the need for the accused or any other person claiming through him to be enjoying the proceeds of crime at the time of initiation of the PMLA proceedings. I have extracted clause 2, which uses the word enjoyment, my lords. Then, but in any given case, if the alleged proceeds of crime have been returned back to the appropriate authorities and the person no longer enjoys the same, then the question of initiating the proceedings under PMLA Act does not arise. The object of the act itself is to prevent laundering, as I will show from that sketch, my lords, what laundering, and after interpretation in Vijay Madanlal, what they say is the requirement, my lords. The object is to prevent laundering, and therefore, when the alleged proceeds of crime are returned back to the appropriate authorities, then the question of laundering does not arise. It may be a different scenario where post initiation of proceedings under the Act, an accused chooses to surrender any proceeds of the crime. In such a scenario, it is arguable as to whether the said act of returning the alleged proceeds of crime post initiation of the proceedings would only be looked into as a mitigating circumstance if it happens later. Unlike a case here, my lords, on 1/10 it was returned, they registered the ECIR on the same day, but they commenced all their inquiry thereafter. However, in the present case, the records disclose that even before the initiation of any action under the Act, be it attachment, adjudication, or confiscation, issuance of any summons under 50, initiation of any search or seizure, the property in question, that is the 14 sites, had already been surrendered to MUDA, and the petitioner was no longer enjoying the alleged proceeds of crime, warranting any initiation of the PMLA proceedings. Next page, let's post the surrender. The ED would get no jurisdiction to proceed under any provisions of the PMLA Act. The essential ingredient, as spelled out under Section 3 of the Act, are totally lacking. There was no alleged proceeds of the crime post 1/10/2024 so as to initiate any action under the PMLA Act. I have quoted Vijay Madanlal, which I am going to be dealing more extensively, my lords. In Vijay Madanlal, though my lords has seen it, but in the aspect of saying what are the ingredients constituting 3, I will point that out, my lords. E, the present initiation of the proceedings by the ED is without the existence of any jurisdictional fact, and therefore all subsequent and consequential proceedings fall through. Latin maxim which my lords uses in a number of matters. Then, my lords, please notice the next page, my lords, there are 12 aspects that have to be fulfilled for the ED to assume jurisdiction. My lords, may just once quickly glance through those 12 aspects, my lords. In which, my lords, in that page, last but one which we get, such property should be projected as untainted money. This is diluted, my lords, in Vijay Madanlal, because they say that and to be read as or. So this is diluted. The rest of it remains, my lords, till the next page. Now, my lords, kindly now notice the diagram which we had put, my lords. My lords had seen it on the last occasion. Please notice page 17 for a minute, my lords. 17. My lords may notice the first column of collection of dirty money. Now, this is nothing but proceeds of the crime, my lords. From the scheduled offense, whatever that you get would be proceeds of the crime. But in the diagrams that we see, they use the word as dirty money, my lords. Now, post this, there has to be some activity for PMLA to kick in, because you need some element of laundering of that dirty money, my lords. That second aspect which my lords would get as placement. Now, under the PMLA Act, we would see they use the word process or activity. Now, process or activity, and it's an inclusive definition, my lords, which says it may include concealment, possession, acquisition, use, or projecting the property as untainted property. So this is insofar as placement is concerned, my lords. Then it would come to the aspect of layering. Again, they say or layering. So, my lords, one of the activities in this diagram would be necessary for you to proceed further under the PMLA. Just the existence of dirty money is not enough. You have to do a process or activity beyond that for it to become an offense under the PMLA. So, this layering and integration, my lords, the usage of the word is or. So, my lords, with this, my lords, the entire argument of mine would be, my lords, to attract the provisions of PMLA, unless there is going to be any process or activity in furtherance of a proceeds of crime, the ingredients do not kick in. Now, my lords, while we're talking about process and activity, incidental aspects that come is possession. Whether would you have possession of the property, is it necessary for you to proceed under PMLA? And the enjoyment of that property, is it necessary for them to initiate action under the PMLA? These are incidental aspects that come in, my lords. And also, what would be the relevant date, my lords, when we say there is an offense under the PMLA? This, along with presumption under Section 24 of PMLA Act, all came up for consideration in Vijay Madanlal's case, my lords. Now, in Vijay Madanlal's case, when the constitutional validity of the act itself was challenged, my lords, the union would defend it through the learned Solicitor General of India and the Additional Solicitor General of India. Now, my lords, my emphasis in pointing out Vijay Madanlal is to see it from the point of view of the union itself as to how they foresaw this entire act and what are the requirements for the initiation of proceedings under the act. Now, for that, my lords, the entire aspect of Vijay Madanlal, and my lords, I'm leaving off the portion where the arguments on behalf of the petitioner challenging the constitutional validity, I'm leaving that portion completely, my lords. I will not go on that. I want to go more on the aspect of saying how the central government viewed this act and what, according to them, are the essential ingredients to constitute the offense. Now, in Vijay Madanlal's case, my lords, in that big compilation, my lords, it's at number 2, but my lords, what I thought would be more easy to follow on Vijay Madanlal is I've extracted it in accordance with the topic wise under Vijay Madanlal, my lords. It would make it a little easier. My lords, this is in specific reference to Vijay Madanlal and Y. Balaji, my lords. These are the two judgments that I am going to be pointing out, which mandates a process or activity in furtherance of a proceeds of crime. My lords, kindly notice the first page, my lords, the three essentials to constitute the offense. The first, that the criminal activity relating to the schedule offense has been committed. This is a mandate. There should be a schedule offense committed. Second, my lords, that the property in question has been derived as a result of criminal activity. Now, this property is proceeds of the crime. That should have been derived. Third is the most essential ingredient, my lords, in page 1, that the person concerned is directly or indirectly involved in any process or activity connected with the said property. Now, my lords, in our case, kindly notice, my lords, 1/10/2024, the property is returned back. So, I'm sorry, two aspects there, my lords. The so-called proceeds of crime is no longer with the petitioner is one aspect. So to say that she is enjoying the proceeds of the crime doesn't arise. And definitely, my lords, the third aspect of saying she has done a process or an activity post that will definitely not be there. So this third ingredient which I have pointed out, my lords, if there's not going to be a process or activity, you can't initiate an action under PMLA. Now, my lords, please notice at page 1 in the bottom, once a proceeds of crime is established from a schedule offense, then the person concerned should have involved himself into a process or activity connected with the said proceeds of crime. My lords, on the next page, Vijay Madanlal, my lords, if for any reason there is no process or activity in connection with the proceeds of crime, then the provisions of the act are inapplicable. This is how the Union of India, led by so-and-so, had interpreted the act in the case of Vijay Madanlal, which till date holds the field, my lords. Even now, it's of precedential value. The said argument had also been advanced by so-and-so who supplemented the argument. Incidentally, the court would also interpret words such as need for possession, whether direct or indirect, dealing with proceeds of crime, and also the date from when it is to be held that an offense under the act has been committed. The court also interprets the legal presumption under 24. My lords,
Yes.
let's go on to the next
Yes,
page,
yes.
my lords. So, my lords, as regard the need for process or activity, my lords, the argument of the learned Solicitor General begins from paragraph 20, my lords. The relevant portion for process or activity, 20.30. Summing up the recommendation of FATF, it is clarified by the learned Solicitor General that even in an act of mere concealment, so my lords, and process of activity of concealment, mere possession or mere use or activity connected with the proceeds of crime per se is an offense. In other words, if a person conceals the proceeds of crime, keeps it in his possession and uses it, he is guilty of money laundering irrespective of as to whether he is projecting it as an untainted or not. This is for the simple reason that if a person conceals something, proceeds of the crime, it's an act committed knowingly, and thus the question of that person projecting that very thing either as tainted or untainted does not arise. My lords may recollect section 3, the last portion of it used the word and. To answer that, this was the argument that and should be read as or. So 20.31, thus so long as any person knowingly becomes a party or is actually involved in any process or activity connected with proceeds of crime, such a person is guilty of money laundering. 20.33, the learned Solicitor General submitted that the interpretation put forth by the other side would effectively result in granting the accused a license to commit the offense of money laundering and thereafter either conceal the proceeds of crime or keep them in their possession or use them and thereby wriggle out of the legislative intent of preventing money laundering by raising a plea that same was never intended. 30.35, again, strong emphasis is laid on the use of the words any in the phase, any process or activity. A careful reading of section 3, PMLA clearly provides that any process or activity of concealment, these are all the activities, my lords, concealment, possession, acquisition, use, and or projecting, claiming it as untainted property, it is submitted that all or every type or species of proceeds of activity connected with proceeds of crime shall be included while interpreting the nature of proceeds. Then again 20.36 activity required in furtherance of proceeds of crime. Now 20.37, my lords, it's page 4. Again, the emphasis, there should be a process or activity. My lords should get that at 20.37. Now, my lords, at this point itself, I'll point out, my lords, this process or activity which they speak about is not for the generation of proceeds of crime. The process or activity which is spoken about is post the proceeds of crime.
Laundering.
That's why, my lords, prevention of money laundering. So you may have proceeds of crime and you have done nothing about it. It doesn't amount to laundering.
Andre, you'll have huge stacks. Don't use it for no laundering.
So here, my lords, activity for laundering. My lords, anything that happens prior to the proceeds of crime, my lords, is investigation of the predicate offense. Because you investigate. Now, for example, a drugs case, my lords, which has come from some place. The investigation takes place under NDPS Act. Ultimately, what is the outcome of that? The proceeds. It stops. Investigation stops there. Now, if that proceeds is used, any further activity, PMLA kicks in. This is how, my lords, the whole aspect of laundering takes place. And that is where PMLA comes in. But if the attempt is to say, we will investigate the generation of crime, then you're intruding into the power and jurisdiction of the investigating officer who is investigating the predicate offense, which you cannot do, my lords. No power or jurisdiction to do that. Now, kindly notice the submissions of the Additional Solicitor General, my lords, how Additional Solicitor General at page 4 itself, Roman 4. Paragraph 53 onwards are the submissions of the learned Additional Solicitor General. Relevant is his interpretation of the presumption under section 24 of the PMLA Act. His contention is that even to have the presumption under the Act, foundational facts have to be established. He says, which are the two foundational facts, my lords? First is that the person should be charged with the offense of money laundering. Kindly notice that, my lords. And secondly, there should be proceeds of crime. Probably it should have been the other way around, my lords. You should first have proceeds of the crime and then laundering. But these two are foundational facts even for presumption under 24 to kick in. That in paragraph 53.31. My lords
Yes.
have noticed 53.31. And then the Additional Solicitor General would contain concept of possession is central to an offense of money laundering. Lords gets that as Roman number 2 at page, Roman 4, my lords, page 2. Because they say possession is not there. 53.42, my lords. It is then submitted that the concept of possession is central to the offense of money laundering in as much as all the 6 activities recognized under section 3 PMLA involve an element of possession of proceeds of crime. He further goes on to state that such possession need not necessarily be actual possession, physical possession, but may also be legal or constructive possession. It is submitted possession of proceeds of crime being key to the offense of money. All activities have an element of possession after 1/7/2005 shall fall within the ambit of the Act. Now, finding of the court on this, my lords, as I pointed out, my lords, the contention of the petitioner, I'm not touching at all. I'm only touching how the union has interpreted this Act. Now, finding of the court is between paragraphs 85 to 391, my lords, in which my lords may kindly notice the object of the Act, which we get at paragraph 97. Even the preamble to the Act reinforces the background in which the Act has been enacted by Parliament, being commitment of the country to the international community. It is crystal clear from the preamble that the Act has been enacted to prevent money laundering and to provide for confiscation of property derived from or involved in money laundering and for matters connected therewith or incidental thereto. It's neither a pure regulatory legislation nor a pure penal legislation. It's an amalgam of several facets essential to address this scope of money laundering as such. In one sense, it's too generic legislature.
I'm sorry.
So, my lords, it's a one of a kind legislation. That's how they hold it. Then, my lords, paragraph 99 onwards, they use the definitions. 2(1)(u), which is proceeds of the crime. That is what you get from the schedule offenses, my lords. My lords may have Roman number 6, page 6, my lords. 106 may kindly be noticed. Roman number 6, 106. Dealing with proceeds of crime by way of any process or activity constitutes offense of money laundering under section 3 of the PMLA Act. So, my lords, kindly notice in our present case, my lords, their entire cases, proceeds of the crime are this 14 illegally allotted sites. That's the proceeds of the crime. Now, it's an admitted case that this so-called proceeds of crime has been given back to the concerned authority, that is to MUDA. There is no process or activity which is done to this proceeds of the crime. Now, if there's no process or activity done, how is it that the ED would get a jurisdiction, my lords, to register an ECIR? The fundamental ingredient to constitute an offense, when it is lacking, how could you have registered it? And that too, in the haste in which it is done, 4 days after the FIR is registered. My lords, 2021 was the allotment. 27th was the FIR registered. 110 they registered ECIR. Would you not wait for an investigation to take place on the predicate offense to establish that there's proceeds of crime? Where was the laundering at that point of time for you to initiate an ECIR? And they very well knew the so-called 14 sites have been returned back. Please notice, my lords, after that, paragraph 109, that the property recovered by them, this is all recovery of property, my lords, need to recover of property to proceed under the provisions of the Act. My lords, 109 deals with recovery, how recovery should be there. That's why, my lords, this Act, when we look at prevention of money laundering, my lords, the Act is designed in such a manner, as soon as you know there's a proceeds of crime from a schedule offense, what would you do first? You want to prevent it from being laundered. Section 5 enables provisional attachment. You do the provisional attachment. You issue summons under 50, call upon them to explain on it. They will come up with an explanation. If you are not satisfied, you feel there's an offense under 3, you proceed with the inquiry, end it up with a complaint. This is how the entire Act runs, my lords. Now, in our case, without there being proceeds of the crime on the day you register it, without there being an attachment, how is it that you proceeded further in that inquiry? Especially at the time when the investigation is going on the predicate offense. So, my lords, then, interpretation of section 3. This would be the most important aspect, my lords. Thoughts has already seen it. My emphasis.
No, I have closed it and kept.
I saw it, my lords. My emphasis is on the usage of the words.
Why Balaji also I saw.
My lords has seen through Vaivala. 3 P's.
Yes.
There should be a person.
Yes.
Then there has to be a process, and there has to be a product. Now, in our case, person is there. Process is not there. Product is not there. So why Balaji clearly lends support?
So you're saying person without product and proceeds.
You can't.
Yes.
You need all the 3 P's put together to have the ingredient of PMLA. That's how why Balaji has gone about it. And in why Balaji, my lords, on the last occasion I had pointed out, in why Balaji, there were 4 FIRs, my lords. 3 FIRs, charge sheets filed. 4th FIR, 1 day before the charge sheet is filed, ECIR. They pointed out how the laundering has taken place. So this ECIR was registered 6 years after the FIRs. Then Supreme Court, when analyzing it, they found that it's a case of laundering. The ECIR is justified in being registered. That is how why Balaji got decided, where they say, my lords, 3 P's are essential. The 3 P's are available in that case. There's a person, there's a process, and there's a product. So, my lords, I'm sorry, my lords has quickly glanced through the whole thing. My lords, all these paragraphs which I have quoted, the emphasis is process or activity in furtherance of a proceeds of crime. Now, in my respectful submission, my lords, even if they consider that these 14 allotted sites are the proceeds of crime, what has happened thereafter? Now this proceeds of crime is back to the authorities concerned. Where is the laundering that has taken place? Now, my lords,
No, the crime is with you, proceeds are with them.
crime of the predicate offense.
Predicate, not that.
That I will face. my
Crime
lord.
is with
Predicate
you,
offense.
proceeds are there.
Proceeds are with them, with the authority concerned.
All right.
No laundering that has taken place. You don't come under any of the aspects of laundering. So how can this ECIR be registered? Now, my lords, subsequently, I'm sorry, my lords, presumption, all that is there in that. The entire emphasis is only this interpretation of Vijay Madanlal in the view of how union has interpreted it, my lords. Not how we had more points to say, but how union has interpreted, which was accepted, is how this is there. My lords, after this Y Balaji, one other decision, my lords, of the Madras High Court, Srinivasan versus Enforcement Directorate,
ಅದೇ umbilical cord decision.
Adralli, they
Hmm.
say the mandate is of possession and enjoyment.
Correct.
Possession and enjoyment. But if there's no possession or enjoyment, then, my lords, the offense is not made up. So, my lords, that is at book 1, page 584 is that judgment, my lords. The emphasis is only on possession and enjoyment. Then one other decision, my lords, quite recently on 3/1/2025 of Jammu and Kashmir, my lords. Now, what happened in that case is the court would hold that they have not been able to establish this proceeds of crime coming into the account, and they have not been able to establish any process or activity thereafter. On that score, my lords, they quashed the proceedings of ECIR. My lords would have the relevant portion there at page 17, paragraph 10. My lords would then notice paragraph 19. The fourth line, my lords, the most important thing is that there must be an activity connected with the proceeds of crime. My lords, gets that portion, my lords. Page 19. Then, my lords, the ingredients, further down, ingredient of the offense of money laundering is not made out when read so. Please notice the three aspects, my lords, which I pointed out. All the three should be there for initiation of proceedings under the PMLA Act. The third is most important, indulging in an activity connected with such proceeds of crime. It needs to be mentioned here that the activity connected with proceeds of crime attributed to an accused must be a voluntary act of the accused. Then, my lords, they would go on to quash the entire proceedings, finding that, my lords, at page 24, that he neither had proceeds nor was he engaging in any activity. So they quashed the complaint because, my lords, at that point of time, in that case, it had ended up with a complaint. They quashed that proceedings. Now, other than this, my lords, on the aspect of whether this entire action is bona fide, my lords, I'm sorry, just one page, if I could request my lords to have in the book that I have given today. Please notice to age Roman page number 21, my lords. My lords, the action between 1992 and 5/1/2021, illegal allotment. Then, when the FIR in the predicate offense was registered only on 27/9, is the ED justified in registering the ECIR within 4 days thereafter on 1/10, especially when the allotment was done on 5/1/2021? So 2.5 years have lapsed, and then comes the predicate offense FIR. 4 days thereafter, in a tearing hurry, my lords, the PMLA proceedings initiated. Second, when the subject matter of investigation in the predicate offense is whether the allotment of the 14 sites is legal or illegal, ED cannot have. Let's have seen the 6 points.
Para 26 for Pankaj Bansal.
Yes, my lords. Because there they say, and there in Pankaj Bansal, my lords, the grounds of arrest had not been given at the time of arrest. They pointed out.
That is the first judgment on that.
Yes, and they point out the events speak volume and reflect rather poorly, if not negatively on ED style of functioning,
Para 26.
para 26. So I'm relying on that, my lords. My lords, one other aspect.
Grounds
which-
of arrest ಅದೇ ಅಲ್ವಾ?
ಹೌದು.
Pankaj Bansal, Prabir, Arvind Kejriwal, Vimal Kumar now. Yes.
Vihan.
Vihan Kumar.
Yeah,
Yes.
that now holds the field, my lords. It's applicable to all offences, including IPC.
Now, that was a case of 420 and 465.
Please. My lords, one other aspect which I had pointed out is after BNSS has come into play, section 107, which was not there under the CRPC.
Yes.
Now, under section 107, my lords, the investigating officer who is investigating the predicate offense, if it comes to his knowledge of any proceeds of crime, he can attach it. Once he attaches it, he informs the magistrate and it is also liable for forfeiture.
Allah, he attaches it and he need not attach it,
Need not.
but there is a provision to attach it.
Provision to attach, provision for forfeiture. Under the PMLA, it is required. You need a process or activity. Whereas under 107, it is not required, my lords. Merely the proceeds of crime can be attached. Then, my lords, 6, need for possession of the proceeds of crime in both is required. They must have some kind of possession, directly or indirectly. 7, the written reasons for believing recorded, it is required under PMLA, not required under 107. They don't have to have written reasons, my lord. 8, crime must be related to specific offense, schedule offenses. Under PMLA, it is yes. Under 107, no. It extends to everything. Then, my lords, property held outside India included. In PMLA, it's included, but it is not included under 107.
That's all.
So, my lords, these are the distinctions that we get of the two. So, here in a case, my lords, when the very allegation of saying whether this 14 sites that have been given are legal or illegal is being investigated, and when that investigating officer has the power to recognize whether there's a proceeds of crime, has the power to cause an attachment of it, then in this tearing hurry, can you have PMLA come within a span of 4 days and virtually doing the very same investigation which is sought to be done in the predicate offense? Investigation in both is one and the same, my lords. That can't be done because this kicks in only after you have identified a proceeds of crime and
No,
a
the
laundering.
parameters of investigation are different.
Different. For laundering.
They are not this, yeah.
Yes, my lord, for laundering. Now, without even having an act of laundering, how do you register ECIR?
No, that to investigate into that laundering only they have
They
released
can't.
this,
For the generation of proceeds of crime, my lords, they can't investigate. Their role comes, their power and jurisdiction.
laundering.
After there's a proceeds of crime, the laundering of the proceeds of crime. This is a distinction. Now, if they're trying to go one step behind and say, we will look at the generation of proceeds of crime, then you're encroaching into the powers of the investigating officer of predicate offense. This would be the subtle distinction, my lords, between the
See,
two.
there was one case which I have written. You argued somebody else in Bangalore. He was a milkman. He takes supari and kills 2 people. That's the allegation. He kills 2 people. Receives a lot of money. That money he launders it, buys apartments, buys cars, everything. Finally, he gets acquitted
Yes.
of that offense in the predicate offense. Now it is laundered, this is registered. Then I said, since that predicate offense is gone, notwithstanding the laundering that is found, goes.
Madanlal.
Vijay Madanlal followed. Supreme Court has stayed it.
They've stayed it.
Stayed.
Otherwise, as of now,
Supreme Court has stayed it saying
as of now,
there was already laundering there.
but as of now, the ratio that is laid down is if there's going to be a discharge, if there's going to be an acquittal,
That
if
is
there's
there.
going to be a
Discharge,
quashment,
acquittal, quashment.
then PMLA goes.
That's what I followed. But
Absolutely.
Supreme Court says
Maybe
there
when they
was-
consider it, they'll have to reconsider Vijay Madanlal. In fact, my lords, in Y Balaji,
no, why I told you that was there was serious laundering of money that he receives from that crime. Those were the proceeds of crime. Proceeds were held by him. If it were held by him, it's all right. But he goes on,
laundered it.
goes on laundering it to many purposes.
Yes, ma'am.
Supreme Court, by detailed order, stated the laundering had happened already on the proceeds of crime.
Then-
He's acquitted of a technical, so I should not have quashed it, is what is said.
And then the ratio has to be.
That's what
My
Supreme
lords,
Court has
probably
said.
then the ratio, my lords, of Vijay Madanlal, the request made in Y Balaji is to refer it to a larger bench. Y Balaji's
No,
case.
that we don't know.
They did.
What
They
I
did.
had held and what Supreme Court has done is what.
May just point out what happened in Y Balaji. The request that was made was Vijay Madanlal's case. There were about 8 review petitions where notices were ordered.
That was rejected, I guess now.
No, no, it's still pending.
Pending.
So, my lords, in Y Balaji, the first request that was done is there are certain aspects of Vijay Madanlal which needs a relook, send it to a larger bench. But the 2-judge bench said, no, we're not sending it. Then the second request that was done is, since there are so many reviews which are pending, let us await the outcome of that. The court said no. They still said Vijay Madanlal has precedential value. We will follow that. And that's how Y Balaji was decided. But as it stands now, the ratio, my lords, is that if there is going to be either an acquittal, discharge, or quashment of the predicate,
That remains.
that remains. The
That
ratio.
remains, even if it is referred to a larger bench, it still remains unless the larger bench would set it aside.
Absolutely.
Mere reference will not make it lose its precedential value.
Well, it's the last aspect that I just pointed before winding up, my lords, is the statement of objection which has been filed. Kindly have a look at the statement of objections.
This is in Parvati's case.
Yes, my lords, in my case, in
So you're arguing the
1132,
1132, yes.
1132. My lords, the respondent ED, they admit, my lords, that the alleged illegal allotment of 14 sites is the proceeds of crime, according to them.
Hmm.
My lords may notice paragraph 3, Roman number 3 and 4.
Hmm.
So this foundational facts, even according to them, 3 and 4, Roman number 3 and 4,
Yes.
and thereafter again at paragraph 4,
Hmm.
what has been given to the petitioner is the proceeds of crime, and paragraph 5,
Hmm.
my lords, paragraph 21 at page 16, page 16, paragraph 21, my lords.
Hmm.
Again, there they say, this is the proceeds of crime. Paragraph 24 at page 19.
Hmm.
Paragraph 26 at page 20.
Hmm.
And paragraph 34 at page 25.
No, that is you're referring to these paragraphs for the reason that there are copious references to 14 sites.
14 sites being the proceeds of crime. Because after those paragraphs, my lords, now they try to give it a different aspect altogether thereafter. Now, when you're saying
Different aspect.
what they're trying to say is what we're trying to investigate now is not just these 14 sites, but all the allotments that have been done by MUDA. It is about 1,708 sites. We are looking into it, virtually investigating into it. And of those sites, we have done provisional attachments of about 160 sites. And therefore, this is much larger than what is there in the predicate offense. This, my lords, if you're trying to investigate to see how the proceeds of crime have come, then you're going way beyond power and jurisdiction. That is exactly what they have produced as Annexure R1 and R2. That's why it's become much more bulkier. Annexure R1 may be noticed, my lords, an internal communication between two authorities of the ED. Please notice, my lords, R1, the page 31. This is addressed to the Additional Director General of Police, Police Wing, State of Karnataka, and it is addressed by the Joint Director of Enforcement. Now, I fail to understand, my lords, what is this information that is being passed on without you even having power or jurisdiction to have an inquiry?
No, section 60.
66 subsection 2.
66.
66 subsection 2 is, my lords.
Information to other agencies.
Other agencies. My lords, here investigation of predicate offense is happening. Are you also investigating into that same predicate offense for you to pass that information?
No, they are conducting investigation to pass it on to other agents. That's what.
They're conducting an inquiry on the proceeds of crime, the laundering of proceeds of crime,
laundering
which can be done. This is not that information that is being given. This is virtually investigation into the predicate offense. And you're passing information of that. How are you parallelly
So
investigating?
that is to other agencies.
Parallel investigation, my lords, of a predicate offense. That is not permissible. They are trying to investigate the very same aspect which is investigated by the SIT.
Kindly see the questionnaire.
Questionnaire also is to that effect.
What questionnaire?
27.
Which questionnaire?
27, along with that petition, Maharaj, that questionnaire was
Along with the
issued along with the
objections.
summons. Kindly see the nature of questions asked. It's nothing but a repetition of what the predicate offense
No,
investigated.
ಯಾವ್ದ್ರಲ್ಲಿ?
Petitionally.
Petitionally, page 27, along with the summons, the questionnaire which is sent last time, Leonard Senior.
In Parvati's case.
ಹೌದು.
Yes,
ಅವ್ರ ಕೇಸಲ್ಲಿ
ಅವ್ರ
ತೋರಿಸಲ್ಲ.
ಕೇಸಲ್ಲಿ
case
ಕಳ್ಸಿದ್ರೆ
they
ನಮ್ಮ
asked-
ಕೇಸಲ್ಲೂ ಕಳ್ಸಿದ್ರು.
grandfather, granddaughter, all in this.
This is a pro forma.
No,
So,
no, can I see the nature of questions asked? No, can page
No,
27.
nature of questions I
Details of
understand,
movable,
but
immovable.
is this a pro forma questionnaire that you ask? ಎಲ್ಲದ್ರಲ್ಲೂ ಇದೆ ಅಲ್ವಾ?
No, no,
it's
no,
a pro
very
forma
specific.
questionnaire.
No, no, it's very specific.
We have devised it.
Kindly see page 27. It can't be
Right
pro
on
forma.
the-
It's very specific. Very specific. It refers to site numbers. It refers to survey numbers.
PMLA ಕೂಡ.
ಇಲ್ಲ, ಮಾಡಿ, ಮಾಡಿ. Let him continue.
Rule 11 of the rules. Yes, sir. Seven ಯಾವ್ದು? ಅಲ್ಲ, there are many rules. Form of records.
Summoning officers shall by exercising powers issue summons in form of the file appended to these rules. How kindly with the form of the file. But we do not report to the other day. Vijay Madanlal refer to how look at form of the file. Whereas I spoke to the director, joint director.
No, but sir, you mean to say that the form cannot be of a different circumstance change. It should be in this manner only?
Seven mandate. There is no difference. Summoning officers, why are they to summon in form of file appended to these rules? And they would refer to it. His the extra the powers flow to officer to the level. We have issued summons as mandated in form of file.
All right.
In continuation of what I was saying, my lords, that the ED,
Well.
my lords, that the ED is doing the investigation into the predicate offense in continuation of
That cannot be done, is
My lords, kindly notice annexure R1. What is it that they're sharing information? R1.
objections.
Objection only R1. This they say under section.
Sharing of information
Sharing of
in
information.
respect of Shri Siddaramaya and others.
Please come below last, second paragraph, illegal allotment of sites. Now, this is part of investigation of the predicate offense. Please notice next one, illegal denotification of land. This is being investigated in the predicate offense.
No, that's the preamble they have drawn to what they are saying.
They say this is what they're doing and passing information. Please notice each and every one, my lords.
During
Please-
the course of investigation, 2 searches were undertaken, directorate. During the course of search,
And then they give a summary for
the
everything.
following was revealed.
And then what? Illegal denotification of land, which is what is being investigated, whether it's illegal or not. On the next page, my lords, please notice illegal conversion of the land for residential purpose. On page 33, they give a summary to it. Gifting of land to Parvati, page 35. Then illegal allotment of sites against the land. Is this not part of investigation what the SIT is doing? Which is the proceeds of crime and the process or activity that you are looking into?
SIT ಯಾವುದು?
Which one?
SIT ಯಾವುದು?
Crime number 11 ಅಲ್ಲಿ SIT,
SIT.
especially Lokaayukta SIT.
Lokaayukta.
SIT. I think they have an SIT there, my lords, for that.
That's all right. Which is this SIT?
No, it's from the Lokaayukta. They had constituted.
Lokaayukta, yes.
My lords, please notice even at page 35,
Hmm.
what is it that you are investigating? How can you investigate what is to be investigated in the predicate offense? Same thing, and this you share information again after doing this so-called investigation. Then, my lords, after all that, my lords, they would say, we have attached certain properties. Page 41
Hmm.
is the provisional attachments done by them to about 160 sites that had been allotted.
What all they do.
Please notice even in this particular attachment, the investigation they say from page 49 onwards.
Hmm.
They register the ECIR and how the investigation, it's investigation into generation of proceeds of crime, not permissible at all. Your role comes after there's a definite proceeds of crime and a laundering of that.
You have so many names are there.
How do
yeah,
all
whose
people
names
who
are-
have been allotted, my lords, allottees,
Oh, allottees.
ಎಲ್ಲ attachment ಮಾಡುದು.
Unrelated to,
And it is unrelated to this 14 sites. 14 sites are given back. There's no attachment of the 14 sites. Then how is it that I'm receiving summons under 50?
We'll see. Yes.
On this
Shall-
basis, my lords, the entire proceedings of ECIR which I have questioned, my lords was pleased to ask, have you challenged the whole process? I have challenged the whole process, my lords, for all these reasons. My lords. Deeply obliged.
What happened to this Justice Hemant Chandan order?
It is
Lord, we are challenging it, Lord.
it's not yet
it's-
challenged.
it's
As
in
of
the
now, it
process.
remains like that. And there, my lords, the 3 paragraphs we have pointed out, 25, 26.
No,
and
that you
28,
last time you
they
said.
hold there is.
Vikram sir ಯಾರಿಗೆ?
No, nothing, Malad. I have nothing more to add. except that-
Just
well,
one
only to
other
point out,
aspect, my lord.
this is the danger, my lords, in assuming the jurisdictional fact. Now, then it essentially balloons into a roving inquiry and it can go anywhere. This is a classic case of assuming that there is proceeds of crime and then starting from there, which is why, my lord, that safeguard is there, that the act would be triggered provided there are proceeds of crime. Otherwise, what happens is you assume that and then you can go in, then the world is open, my lords, which is what happens. One more aspect.
Well, it's one last aspect which we want to point out, my lords, through media that we have come to know, that in the predicate offense itself, now a B report is being submitted. In the predicate
The court,
offense. No,
Lokaayukta police.
look at it. So, my lords, an additional
How is-
factor.
How is that relevant to this?
Just an additional
Because
factor.
that procedure will go on there.
Yes, ma'am. Procedure will go on there. That's why, my lords, I didn't use it as a point to say this has to be quashed on that score. No. It's only an additional ground, my
Because
lords, where they
whatever-
find nothing.
Whatever is done there, procedure there will have to be followed.
Yes.
This has nothing to do with that.
Deeply obliged.
Sir, ತಾವು ಮುಗಿಸಿದಿರಲ್ಲ last time. Yes.
Lord,
ನಿಮ್ದು ಬಿಡಿ. ನಿಮ್ದು is a different. So like you assumed office in 2023.
my lord,
2023.
June 2023. ಅವ್ರು ಏನಾದ್ರು ಒಂದು ತೋರಿಸ್ಲಿ ನೋಡೋಣ, ಜೂನ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಟು ಜೂನ್ 2023.
ಇಲ್ಲ ಸರ್ 21 ಗೆ ಎಲ್ಲ ಆಗೋಯ್ತು.
ಅಷ್ಟೇ.
ಜೂನ್ 23 ಆದ್ಮೇಲೆ ಆಗಿರೋದು ಒಂದೇ ವಾಟ್ ಇಸ್ ದಟ್ ಕ್ಯಾನ್ಸಲೇಷನ್.
ಅಲ್ಲ, ಅದು ನಾನಲ್ಲ, ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಮೂಡಾ ಕಮಿಷನರ್ ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ, ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸರೆಂಡರ್ ನ. ದಟ್ ಮೂಡಾ ಕಮಿಷನರ್
ಸರೆಂಡರ್ ಅಂಡ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಒಂದೇ ಆಕ್ಟ್ ಹಸ್ ಹ್ಯಾಪೆಂಡ್ ಆಫ್ಟರ್ ಯು ಅಸ್ಯೂಮ್.
ಅಷ್ಟೇ. But that MUDA commissioner who passed the order accepting the surrender and cancelling the allotment that was made earlier, my lord, he is the petitioner before a coordinate bench of dishonorable court.
That same.
Yes, that Satish. I'm sorry, Satish. Natesha. And dishonorable court would say, no, you could not have issued the notice under section 15.
Yes, sir.
the Supreme Court has repeatedly said, do not read judgment like a statute. But my learned friend went beyond that. He is reading the submissions made by the law officers as a statute. One cannot read portions of the submissions to interpret as a law. We have to understand for what purpose those submissions were made. So therefore, when judgments cannot be understood as statute, the submissions made by law officers cannot be treated as statute. We have section 3 that has been interpreted by the Honorable Supreme Court. That should be.
No. His submission was, what is the intention of the what is the mind of the union also is what is.
No, but one cannot take out piecemeal submissions to it. One has to understand the entire judgment and then to it. So, my lord, piecemeal reading does not give the entire intention of what the Union of India is. So, therefore, my lord, my respectful submission is that it is not permissible to read a portion of it and say, this is what the government intended. My lord, our submissions have been considered by the Honorable Supreme Court and interpreted. It is the interpretation of the Supreme Court which matters. I am grateful, Your Worship.
Fantastic. Yes.
2-3 aspects of it.
Rarely some great submissions. Yes. Yes.
As my lord has pointed out, non-compliance would entail arrest and all that. You ought to have issued me a notice under section 161 CRPC.
Statement recording.
Mate?
I am not a police.
Ah,
Supreme Court says I am not police.
sorry, but section 65 says the provisions of CRPC are made applicable. Issue me a notice. Why a notice under section 50? ಇನ್ನೊಂದು ಹೇಳಿದ್ರು ಅವರು 482 ಇನ್ವೋಕ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ? To secure the ends of justice, to prevent the abuse of process of law,
Miscarriage of justice.
miscarriage of justice.
So
We
long
can
as
suddenly
it's
invoke the
seen-
jurisdiction of the court under section
Mike.
482 or even under article 226 and 227 of the Constitution.
So long as it's seen that the basic ingredients to constitute an offense is missing, then to say, no, allow us to have a roving inquiry, we will fish and we will see what we can get out of it. That is totally impermissible, my lords.
Yes,
If
sir. They will fish to find something fishy.
Fishy and then go. That can't be done. Now, if at all, my lords, they're not in a position to show that there was an activity or a process in furtherance of this proceeds of crime, where lies a power or jurisdiction to register an ECIR and have an inquiry? Very basic. And
That
then,
you
my lords,
can't.
no, my lords, then,
Register ಮಾಡಕ್ ಪವರೇ ಇಲ್ಲ ಅಂದ್ರೆ
ಅಲ್ಲ, basic ingredient ಇಲ್ದಿದ್ರೆ, my lords, now when we say basic ingredient, right from Madanlal to whichever case that we see, my lords, if the basic ingredient to constitute an offense is lacking, you don't proceed further there.
No,
Or
that
its
is
courts will interfere.
the reason for quashment.
Quashment.
ಅವ್ರಿಗೆ ಪವರ್ like to register an ECIR ಅವ್ರಿಗೆ ಆಗಲ್ಲ ಅಂತ. It's not correct.
So, my lords, now to say we will issue summons and will test the waters and see what we get out of it. My lords, issuing summons under section 50, will there not be some basis for the issuance of summons? Because, my lords, this particular act goes on the aspect of reasons to believe, not reasons to suspect. That is exactly what Vijay Madanlal says. You can't go on the aspect of, I am suspecting something, I will do an inquiry. No, you should have concrete reasons to believe. And that reasons to believe, my lords, in my respectful submission, in 8 provisions of the PMLA Act, it is there. Section 5, 8, 16 to 21. Reasons to believe. Now, without having any reasons to believe, let me find out what exactly I can get out of this inquiry. That can't be permitted. And that affects my own right for a fair investigation or an inquiry. My lords, I again go back to Article 21 there. This is one aspect. Finding fault with me, returning these properties, my lords, as though it's an admission of guilt. My lords, I am the wife of the Chief Minister of the state. And if someone is going to be pointing fingers at the Chief Minister, my lords, my respectful submission is I would have a moral responsibility to ensure that such kind of allegations or such kind of belief that the public has, it should be drowsed at the earliest. I return the property to the rightful authorities. That can't be treated as saying he is admitting to his guilt. No, this may definitely not be so, my lords.
But predicate offense will not vanish.
No, no.
Because you have
No, my lords,
this
we are
will consider.
absolutely, my lords. Then, my lords, for them to say, with belief,
No predicate.
no,
ಅಲ್ಲಿ ನಿಂದ್ರೆ ಇಲ್ಲ.
Yeah.
Oh,
my lords, then to say, my lords, this allotment of sites itself is an offense. On what basis are we saying this? On what basis is it being said? They have concluded that it is as though it's an offense. So, my lords, when they're saying all that we're trying to do is we're just trying to find out some information, that is not what they're doing. Please notice page 63, R1. They specifically say it's an offense of money laundering. Please notice what they say in.
I've seen, yes.
Yes, my lords. So, if there's specific case that it is a case of money laundering, then can we put it across in an innocent manner in saying, look, all that I'm asking is for some statements? No. Please notice 63, my lords. in the statement of objections, page 63,
Yes, the beginning.
categorically they say offense of money laundering by whom? They name the chief minister, my lords,
Summary.
and making it appear nothing. After all, we have just issued some summons for some inquiry. May not be so, my lords. It has serious consequences. And if your foundation is not there and you do things in such tearing hurry, it is a case where the court will definitely interfere, my lords, either to meet the ends of justice or to prevent an abuse of process. This is where it stands, my lords. So
ನಿಮ್ದು ಇದೆಯಾ ವಿಕ್ರಮ್ ಇನ್ನು? ಇಲ್ಲ. ಸರ್ ನಿಮ್ದು ಆಯ್ತಾ? ಆಯ್ತಲ್ಲ?
Great.
ಬರಕ್ ಹೇಳಿ. ನಾನು ಬರ್ಕೊಂತ. ಇಲ್ಲ ಎಲ್ಲರದು ಬರ್ಕೊಡಿ. ಸಾನ್ಯಾ.
File ಕೊಡಿ sir, file ಕೊಟ್ಬಿಡಿ sir.
ಏನ್ ಮಾಡೋದು?
ಮೇಕ್ ಮೀನ್ಸ್ ಎಲ್ಲರದು ಹೆಸರು ಬರೆದು ಜಸ್ಟ್ ಗಿವ್ ಇಟ್.